Hi, and thanks for taking the time to visit. I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City, and today we're talking about how it just got much more difficult to apply for an E-1 or E-2 visa by receiving citizenship by investment into a treaty country. In this video, I'll walk you through these changes and what they might mean for you. Before diving in, please take a moment to subscribe. By doing so, you'll stay updated on our firm's most current and trustworthy information about U.S. immigration, including options to visit, work, or live in the United States. So let's get back to our discussion about how the citizenship by investment rules recently changed for E-1 and E-2 visa applicants. To start, let's quickly review one of the fundamental requirements for an E-1 or E-2 visa, that the applicant must be a national of an E-1 or E-2 treaty country. We call this the nationality requirement, and we have an entire video that focuses on this requirement, which we'll link to below. In short, the nationality requirement states that anyone applying for an E-1 or E-2 visa must have a passport from an E-1 or E-2 treaty country. We call these treaty countries for short, and there are dozens of them, and they span the world. The U.S. Department of State keeps a list of these treaty countries on its website, which we'll also link to below. Now, there are a number of countries that are not E-1 or E-2 treaty countries. These include China, India, Vietnam, Brazil, South Africa, and others. In the past, those who were not nationals of a treaty country could still apply for an E-1 or E-2 visa by first receiving citizenship in a country that is a treaty country. Grenada and certain other treaty countries made the process relatively quick and easy by introducing citizenship by investment programs. These allowed people to receive citizenship by basically just investing money in the treaty country. For many of these countries, including Grenada, the applicant didn't even need to set foot in the treaty country. Once the applicant received their passport from Grenada, for example, they satisfied the nationality requirement and could then apply for an E-1 or E-2 visa. This changed in December of 2022 when President Biden signed into law new restrictions on how these citizenship by investment programs can be used toward an E-1 or E-2 visa application. The new law, called the National Defense Authorization Act, or NDAA, added language to the Immigration and Nationality Act. This new language said that someone applying for an E-1 or E-2 visa who got treaty country nationality through financial investment must have been domiciled in the treaty country for a continuous period of not less than 3 years before they apply for the visa. So what does it mean to be domiciled in a country? And how do you show that in the visa application? To answer this, it's helpful to think about another example where domicile is relevant. Specifically, E-1 or E-2 applicants from the United Kingdom. Now, the United Kingdom is unique when it comes to E-1 and E-2 applications. Most E-1 or E-2 applicants only need a passport from a treaty country. They usually don't need to have lived or even visited the treaty country. For example, if someone born in Uruguay has a second passport from Italy that they got through a parent, they can apply for an E-2 visa based on that Italian passport, even if they've never been to Italy. This is not the case for nationals of the United Kingdom. Nationals of the UK must show that they are actually domiciled in the United Kingdom, which generally means that the UK is the country where they permanently reside. Applicants from the UK have shown this by including in their visa application documents that show their ties to the UK, such as a mortgage or a lease agreement showing that they own or rent a home there, pay stubs and bank statements showing that they work there, tax documents showing that they pay taxes there, and school enrollment documents showing that their children go to school there. These are just a few examples. The US government usually doesn't require any one of these documents as proof that a person is domiciled in or permanently resides in the UK. Instead, the government usually looks at the documents as a whole to make its determination. We would expect that the government will take the same approach when deciding whether an applicant has met the new domicile requirement as it applies to applicants who receive treaty country citizenship through investment. As a result, E-1 or E-2 applicants who receive citizenship in the treaty country through investment should be prepared to include in their application proof that they actually lived in the treaty country for a continuous 3-year period before they applied for the visa. Among other things, they can include some of the documents we mentioned before. Documents showing that they owned or leased a home, worked in the treaty country, paid taxes there, enrolled their children in school there, opened a bank account there, had a driver's license there, etc., etc. If the applicant traveled outside the treaty country for an extended time during that 3-year continuous period, they should be ready to explain with documentation how that departure did not terminate their permanent residency in the treaty country. Based on the language of the new law, it does sound like once the continuous 3-year period of domicile is complete, the applicant can move to another country and apply for the E-1 or E-2 visa even if they're not domiciled in the treaty country at the time they submit their application. In conclusion, while the enactment of the NDAA creates a significant additional hurdle for anyone who plans to apply for an E-1 or E-2 visa but who does not already have treaty country nationality, the door for those individuals is still open. There still remains a pathway to an E-1 or E-2 visa for those born in China, India, Vietnam, Brazil, or another country that does not have an E-1 or E-2 treaty with the United States. Given how attractive the E-1 and E-2 visas are for those who want to start or build a business in the US, that's good news, and these additional hurdles might nonetheless be worth navigating. We hope this video was helpful. If it was, please go ahead and click the like and subscribe buttons to stay updated on future videos about visa options and travel to the US. Thank you for watching.